Good morning. Let's go through the definitions that you're going to need to know if you're going to understand your RFC, residual functional capacity, that the SSA has to determine for you before they can determine whether you are disabled or not. So that would be generally under a step 3 of the sequential evaluation process. So RFC is the residual functional capacity. That means residual, remaining capacity to function in various relevant ways to a working environment. So we have physical things and we have non-physical. The physical things, well, they can be exertional or non-exertional postural. But for the exertional ones, which is the main crux originally that they have to determine, it is the exertional RFC, the portion of the RFC that defines how exertional you can be. There are 5 levels. There is sedentary, light, medium, heavy, and very heavy. So let's get into what those mean. Let's start with very heavy work. It's kind of self-evident from the name of it. It's very heavy work. It involves lifting things greater than 100 pounds at a time and frequently carrying things weighing 50 pounds or more. That's really arduous work. If someone can do that kind of work physically, unless they are seriously mentally ill, I don't even know how they would ever be found to be not disabled. Generally, if you are deemed to be able to do very heavy work, you can also do work that is much later than that. So it kind of leaves it wide open for everything less than, which would include then the next level down, which is heavy work. Heavy work involves lifting no more than 100 pounds at a time, with frequent lifting or carrying of objects weighing up to 50 pounds. And as they emphasize again, if you can do heavy work, they will also determine that you can also do medium, light, and sedentary work. Those are the things that are lighter than heavy work. Medium work. So that's right under heavy work. Medium work involves lifting no more than 50 pounds at a time, with frequent lifting or carrying of objects weighing up to 25 pounds. That would be medium work. And of course, if you can do medium work, they're going to find that you can also do things lighter than that, including light and sedentary. Light work. Light work involves lifting no more than 20 pounds at a time, with frequent lifting or carrying of objects weighing up to 10 pounds. Even though this is a little broader because they talk about some other things. Even though the weight lifted may be very little, a job is in this category when it requires a good deal of walking or standing. This is why we say that light work is generally being able to work at least 6 hours of an 8-hour day. They also decide it's kind of light if it involves sitting most of the time, but with some pushing and pulling of arm or leg controls. So a job that might otherwise be sedentary will be light if it involves a lot of pedal pushing, such as perhaps driving. To be considered capable of performing a full or a wide range of light work, you must have the ability to do substantially all of those activities. If someone can do light work, they will determine that that person can also do sedentary work, unless there are additional limiting factors, such as some sedentary work includes the loss of fine dexterity or the inability to sit for long periods of time, which would then knock out the ability to do a sit-down job all day long. And they bring up the point of fine dexterity. And by the way, I'm looking at the CFR section here, and I'm going to link it at the end so you can go and read it for yourself. Look for, I think I'll do like a card. You'll see it probably up in the upper right-hand corner at the end. You could just click on it. The loss of fine dexterity is really important because for a sedentary job, because, and we were just talking about light, but they bring up the point about loss of fine dexterity, but bilateral manual dexterity, because a lot of sit-down sedentary jobs are because you're not really doing a lot of moving around elsewhere, you're going to be doing a lot of things in front of your face on the desk, bench work, that kind of thing. And last but not least, the least exertional of all. So this is often what people are striving for, to prove that they can do no more than this kind of work if they are, say, 50 to 55. because even if you can do the sedentary work at 50 to 55, if you fall into a certain additional vocational limitations, including past relevant work limitations, you can be found disabled even if you can still do sedentary work from a physical standpoint. Okay. So as I say, sedentary work involves lifting no more than 10 pounds at a time. So remember, light work was being able to lift no more up to 20 pounds at a time. So sedentary is lifting no more than 10 pounds at a time, and occasionally lifting or carrying objects like docket files, ledgers, and small tools. So those things would presumably be 10 pounds or less. And it says, although sedentary job is defined as one which involves sitting, they acknowledge that a certain amount of walking or standing is often necessary to carry out the job duties. And that would include delivering maybe a file to a coworker in the office. Not a lot of walking, but a little bit of walking, might be necessary. And they do note that jobs are sedentary if walking and standing are required occasionally and other sedentary criteria are met. Okay, so those are the 5 exertional limitation levels. They are really important if you are doing a grid analysis. Super, super important. I have a case right now where the person was old enough. We always say, 50 or older is really kind of the area where grids, even though they do note younger ages, those are almost impossible to meet. So over 50 is when they become reasonably possible. And this particular young 50s person was denied because a judge found very limited physically, too light exertional level, not as light as sedentary. And so the person was denied and they would have otherwise prevailed under the rules, even though being found to do sedentary work means they could physically do sedentary work. Due to special rules that are applied to those of us over 50, due to our difficulties adjusting to other work, you can prevail nonetheless. So that's where these definitions come in great handy, are very, very important, and will define whether many people prevail or do not prevail on their claim. So know them, live them, love them. Click on the card at the end that I mentioned, because that will have the link directly to what I'm looking at. Okay, I hope that helps. If you're looking at grids, or if you otherwise just need to know, if you get your ALJ denial, and you will see under the bolded paragraph where the judge decides what your residual functional capacity is, that'll be in the first sentence of that bolded paragraph. It's a few paragraphs. When I say paragraphs, I should say sections, because but it's where they bold out the beginning of the new section and they're numbered. That's where they're going to talk about which one they applied to you, and you'll figure out from that how the jobs that the vocational expert or the judge said you could do, unless they said you could do prior work, the prior work you had, which is even worse. These exertional limitations that are part of the definition of your RFC are extremely relevant. Okay, have a great night, guys. Bye. Or great morning, whatever time it is for you. Bye, guys.